And everyone should have a packet that contains all of the information, the agenda, and the subcommittee's reports. If you don't have one, please let either Cassie or Pat know. We do have some members of our task force that are joining us remotely, so we want to welcome you too and say hello. And do you all have a copy of the packet? Yes, fantastic. I see thumbs up and head nods. Fabulous. All right, so you should have in your packet, and hopefully you've had a chance to review the minutes from September 27th, 2023. And if there are no questions regarding the minutes, I'll entertain a motion.
Move to adopt.
There is a motion by Chairman Wiggins to adopt the minutes. Is there a second?
Second.
There is a second. All those in favor say aye.
Aye.
Are there any opposed? Seeing none, we're going to go right into subcommittee number 3 with our chair, Judge Cheryl K. Pierce. And so we're really looking forward to the presentation that you have. As the committee and for those who are watching may recall, for our first meeting, there were several issues that were in Senate Bill 2384, and we divided all of those topics into subcommittees. And so we're very pleased to have Judge Pierce to be able to present for us. If you don't mind, could you go down to the end of the table just so everybody can see it?
Yes.
Thank you.
I started out down there, but I moved up here because it's harder to see on Zoom, so.
Or, I'm trying to think, does everyone on Zoom who's attending remotely, are you able to hear when they're presenting from the end of the table? I hear head nods. I see head nods, pardon me.
As long as they're speaking in a microphone, we hear great.
Okay, perfect.
Okay, how's that?
If you could move the mic a little bit closer to you.
Okay.
I'm not sure if it's on.
It's on, I think.
Okay, I can hear you now. Can y'all hear remotely? I see Judge Dickinson, yes. All right, perfect. All right, thank you. Well, we're going to turn it over to you, Judge Pierce.
All right, thank you, and thank you for the opportunity to allow us to present today. I want to take just a minute to thank all the members of our subcommittee for working really hard on the topics that we were assigned and for putting up with our Monday morning Zoom meetings that we had on Title IV. And to CPS and OSPD for participating in meetings with us as well and giving us input and recommendations. And Judge Hudson for driving up from the coast today to be with us, to be able to help us answer questions that the committee may have. So I'll start with and I apologize, the report is very lengthy, but we felt like it was important information that we needed to include. So I'm going to try to hit the high points. I'm not going to read all the way through it. And then that'll leave us some time for questions and discussion. So our first area of concentration that we were tasked with looking into was to review of the guardian ad litem role in the foster care system and termination of parental rights process, including the proper responsibility for payment of guardians ad litem, how much they should be paid, whether more guardians ad litem are needed, and whether Title IV-E funds can be used for that purpose. So just what is the role of the guardian ad litem? So Rule 13 of the Uniform Youth Court Rule states in part that the court shall appoint a guardian ad litem for the child when custody is ordered or at the first judicial hearing regarding the case, whichever occurs first in every case involving an abused or neglected child, which results in a judicial proceeding. And the duties of the GAL are to protect the interest of the child for who he or she has been appointed as guardian ad litem, to investigate and make recommendations to the court or enter reports as necessary to hold paramount the child's best interest. So the guardian ad litem shall inform the child, the parents, the guardians, or custodians that the role of the guardian ad litem is to act as an arm of the court in protecting the interest of the child and not as the party's attorney, and that any statements made to the GAL affecting the health, safety, or welfare of the child will be reported to the court. So now, since the child has been made a party to the case in abuse and neglect cases and is entitled to representation, the guardian ad litem may serve a dual role unless a conflict arises. and at that point, the minor is entitled to a GAL and an attorney in the proceedings, beginning at the shelter hearing or at the point the conflict arises for the GAL. So I thought it was important to note that Rule 13C does require the GAL to immediately advise the child and parents that they're acting as a best interest attorney and not as the child's attorney. And this seems to be in direct conflict with the newly adopted statutes that provide that the child is a party to all youth court cases and is therefore entitled to the appointment of a traditional attorney. And so the guardian ad litem may serve a dual role as long as there is no conflict of interest, and if there is a conflict that arises, the guardian ad litem has the duty to inform the youth court, and they'll retain the guardian ad litem to represent the best interests of the child and appoint a separate attorney to represent the child's preferences as required by Uniform Rule of Youth Court Practice 13F. So the next question was, how much should GALs be paid? Rule 17D of the Mississippi Rules of Civil Procedure sets out that in all cases in which a GAL is required, the court must ascertain a reasonable fee or compensation to be allowed and paid to such guardian ad litem for his service rendered in such case. So currently, the responsibility for payment of the GAL in youth court cases falls on the counties. And some counties do have a permanent GAL that is paid a set salary. In other counties, the GAL is paid an hourly rate as determined by the court. I know that Judge Dickinson has a full-time GAL in his county, and that rate of pay was based on the number of years of that GAL, the experience and the years that GAL has been working in that court. So the rate of pay for GALs does vary greatly from county to county throughout the state. And just anecdotal information indicated that some counties do pay GALs on an hourly basis at a rate of anywhere from $75 to $100 per hour, with the expectation that most youth court cases would not involve more than 10 hours of investigation and court time. And as Justice Beam pointed out in her memo to the committee, the rate of pay is negotiated at the local level, which results in serious differences depending on what part of the state the court is located, and recommended that a standard pay scale would be helpful. In the TPR and adoption proceedings, the fees for the guardian ad litem are paid for by CPS. And as Justice Beam also recommended in the memo, or that the memo recommended, and as we have discussed in prior meetings, that having the same GAL throughout the entire court process when it's possible would reduce the workload and the attorney's fees involved in each case. So, Professor Calder also pointed out the term GAL applies not only in abuse and neglect cases in youth court, but also to cases involving mandatory appointments in chancery court, and there should be no distinction in how much GALs are paid, as their duties are the same. And there are also other circumstances in the court system where GALs would be appointed in other contexts, such as for an adult, for a victim of elder abuse, or even as the attorney to represent a party with a lack of capacity in civil litigation. So that brought us to the question of whether more GALs are needed. And as of August 14th, 2023, there were 266 certified GALs listed on the Supreme Court website. And as of August 1st, 2023, CPS had 3,719 children in custody. That would be an average of 14 cases for every certified GAL in Mississippi. However, not all of the certified GALs actively take appointments in youth court, and in addition, this does not include mandatory GAL appointments in chancery court. So with regard to whether more GALs are needed, the greatest need seems to be in the rural counties, where the number of practicing attorneys are lower and the attorneys are often required to serve more than one role in youth court. For example, an attorney in a rural area may sometimes serve as a parent representative, as an attorney for the child, or as a guardian ad litem, and this can get confusing for the parents and the children trying to understand the role of the attorney in their case. And that, coupled with the fact that now the child is entitled to an attorney in addition to the GAL when there's a conflict, that could result in a serious shortage. The next question was, can Title IV-E funds be used to pay the GAL? And the short answer is yes, and there's a lot more in-depth information. Yes.
Pardon me, before we move on to the funding, I wanted to see if there were any questions.
Okay.
Okay, seeing none, proceed.
Okay. So I do have a good bit more information that we have in the report on the funding, so we'll come back to that toward the latter part of the report. But some other issues of the GAL that we discussed in the subcommittee was the need for the guardian ad litem to take a more active role in the cases that they have in youth court, and the need for a written report to be presented in every case. CPS was very interested in that recommendation that the GAL meet with the children, meet with the parties before court instead of at court. Judge Dickinson has developed a form report which includes all of the information that he wants from a GAL in termination of parental rights cases, and also requires a form CPS report for each hearing of a protection case. So the subcommittee discussed the possibility of some type of form report that in cooperation with the Judicial College could be developed and incorporated into my kids for the GAL to use. It may not be needed in every case, but especially in TPR cases and other cases where the court may want it, that would be a good option for them. And then we brought some information about CASA volunteers, and we do have a representative from CASA on our subcommittee. CASA volunteers may be appointed in addition to a certified GAL in youth court. And GALs in Chancery Court must be an attorney, but GALs in youth court do not have to be an attorney. So the question then was, should CASA volunteers be required to take the GAL training required by the Mississippi Judicial College in addition to their CASA certification? And I think yes, if they're going to serve as a GAL at any point, they would need to do that. And Judge Dickinson pointed out that in many states, CASA volunteers also serve as the GAL in child protection cases. Are there any questions about the GAL, the issues that we were looking into on that at this point before we move to the parent rep section?
Judge Hudson?
Just one comment.
And I just want to say that Judge Hudson, we're very happy to have you to be a part of our hearing, our task force hearing. Everyone knows the wealth of knowledge that you have in this area. I'm asking for unanimous consent for members of the task force that he be able and permitted to make comments and ask questions. I think that the knowledge that he has is invaluable, and we're glad that you took time to be with us today.
The only real comment I have is that I know that on the question of guardian ad litems, that then there develops a conflict between the guardian ad litem and the child, and there has to be an additional either guardian ad litem or attorney for child appointed at that point. Most of the national advocates indicate that the best practice would be that the guardian ad litem become the child's attorney and a new guardian ad litem be appointed. And the reason for that is that guardian ad litem probably possesses confidential information because of their role as a guardian ad litem for the child, and that would protect whatever confidential information has been shared by the child with the guardian ad litem if that guardian ad litem then becomes the lawyer for the child. And that's just a national advocates have said that in these situations. There are several states that do that create a guardian ad litem until you have a conflict, and that's been their response. The best practice is just to simply have a separate attorney from the very beginning in that process. But where there's not one, they suggest the guardian ad litem then become the child's attorney.
Thank you, Judge Hudson. And I did have a question too. And you may have mentioned this earlier in your comments when you first started your presentation, but how much is it that the GALs, how much are they paid for CPS?
Are you talking about in the termination of parental rights cases?
Yes.
I may be able to offer some just from Harris County.
And we also have Commissioner Sanders here as well.
Go ahead, Judge.
I was just going to say, I have a flat fee that on the termination of parental rights cases, it's $850 for for every termination of Carmichael's case, unless that case ends up being a long, complicated trial, and it will be more. I don't believe I've ever signed an order for a payment to guardian ad litem in excess of $2,000. Like I said, 95% of them are going to be about $850. That's Harrison County.
And to answer your question, there's a complete lack of consistency. So we just get invoices. We've taken that in-house to review them. So, I've gotten some for $7,500 with no documentation of what was done. So it's federal money that we're using in conjunction with state funds, and I need more substantiating documentation to go on to protect the state when we use those federal funds. And consistency in rates would be very, very helpful.
Commissioner, just a note, I don't know what documentation would be helpful in terms of what has been done on the case, but as Judge Pierce mentioned, I do have a kind of form report that the guardian ad litem termination cases will complete, and she lists out everything that she's done, from interviewing a child to visiting a school, and foster parents, or whatever it may be, interviewing biological parents. I don't know, you may run into some confidentiality issues if you were to use those reports as documentation, but if there's anything that I can get to you that will help with the documentation on what the GALs have done for TPRs, just let me know and I'll be happy to help.
I'd just like to get to a point where we have a traditional breakdown of hourly work that's been done the same way a public defender would, and the same way I would in a law firm. I spent 1 hour interviewing the child rather than, and I think a set fee is not a bad idea, but just a breakdown of how they spent their time. I don't necessarily need the report, but it would be good to know that a report was done. And additionally, I have a question about the conflict of interest when that arises and how that would be identified. And I guess that would be for Subcommittee 3.
I think what I saw and what I've read is that the guardian ad litem has the duty to present to the court that when they find out that there's a conflict that arises. And I know that's probably not going to happen a lot with younger children, but children that can express their interest, I think, is where that's going to come up.
Well, and that's where I don't know exactly what regulations or what GALs are taught right now, but a requirement that they ask the child what they want and present that to the court would be, in my opinion, the most efficient way to know if there's a conflict.
I agree, and that I only had this happen one time since that law went into effect. I think that was the issue, that what the child's wishes were conflicted with what the guardian ad litem believed to be the best interest of the child, so we had to bring in another third person to come in.
If I may add to that, from the youth and their experiences, if they're only talking to the guardian ad litem when they come to court that day, there's not really any time for pre-planning or pre-communication. I do like the concept of the document being done ahead of time, so there has to be some type of communication before they end up in court. And additionally, most of the youth in our program will tell you they never met their guardian ad litem, and they did not know what that position was. And so, both the documentation on the activity, as well as how to identify when there is a divergence of opinion, there has to be a way to operationalize it.
Yeah, it's kind of short. Thank you. It would seem to me that best practice, especially now that the child is a party to those actions, that the child be in court and just ask them what they want. I mean, that's direct to the point. The child has a voice, they're heard, and the judge can identify conflicts, because having someone to say, oh yes, I talked to him and I don't think there's a conflict, well, that's secondhand information subject to interpretation, when you can just ask the child.
I'm going to recognize Chairman Wiggins.
Thank you, Madam Chair. I was going to comment on a couple things and get thoughts, but in the report, and if y'all want to elaborate, please do, there's a paragraph that jumped out at me where it says, I guess it's on page 3, the term GAL applies not only in abuse and neglect cases, but also to cases involving mandatory appointments in Chancery Court. And then the responsibilities of GAL in Chancery Court are much greater, as they are usually the only neutral person investigating the case to determine what is in the best interest of the child, so that time they expend may be greater. And I guess I have a little bit of personal, in fact, I have personal experience from attorneys I work with, and with what is being paid to these GALs is not worth the amount of effort and time that goes into what a GAL has to do. They're not being paid what it's worth, and you get what you pay for. And with all due respect to Judge Dickinson, $800 for a GAL is not good. And I will say this, it's about the same in Jackson County. And I know for a fact that there's an attorney in my firm who loves GAL work and stopped because she cannot make a living doing that. And I think, and then to Commissioner Sanders' point about it's different in every county, and in the rural counties, I'm glad we're talking about this, because I think this is a serious problem in this state. And I see heads nodding. And the part about sometimes the only neutral person, I can't tell you how much that happens. The GAL is put in the middle between warring families and warring parties in the state, and they end up getting all of it. And they're very important, the reports that they do, and they are the neutral party between all of these. And then yes, there is in youth court, the litigants don't understand the difference between a GAL and their own attorney. And so I guess what I'm seeing in this report meets the anecdotes that I've seen. Now, the report is recommending counties to pay for it, and maybe I'll do this question, Judge. Not every time, but when we try to put stuff forward in the legislature, for example, when we try to say the counties need to pay for court reporters, we get so much pushback, it's ridiculous.
Yes, we do.
Thank you, Madam Chair. And so if we come forward and say the counties need to pay for the GALs and all this, you can bet there's going to be pushback. So is there any recs of how we can address this issue?
Well, I think the recommendation, and Professor Calder had provided that input, the recommendation was for cases that, abuse and neglect cases that arise first in Chancery Court, where a parent might be indigent and not able to pay a GAL. Because typically the parties pay the GAL in other cases.
Well, then we get into the whole point about whether the parties even pay.
Right.
Because then, and I noticed in your report, which I think was great in here, it says there have been annual efforts to pass a bill that the fees charged by GAL are subject to collection and not a court order, which I'm not sure what that means, but my guess is that people don't want to pay for the GAL fees, and they don't want to be told by the court that they have to pay them. And so the collection then gets put on the backs of the Chancery Court, which I'm personally am fine with. But it tells me that people in the legislature are filing these bills. And then you have, what I've seen is some of the GALs are similar across. So if you're doing them in youth court, you're also doing them in chancery court. And then the number 266 certified GALs, and just in custody, 3,700 kids, 14 for every one. $800, it just doesn't work. And one thing that I've seen throughout this task force is it seems there's a lot that goes into these cases. And we're asking under the current system for attorneys to really be paid below market value to do what needs to be a truly difficult, probably the most difficult cases in the state of Mississippi. I know I'm going on, but I think I'm glad we're talking about it, and I hope we can come up with some ideas. But I think it's just like, and I've sat in the appropriations committees, we've got to get our pay up for our social workers. Well, the legislature has stepped up in different situations. We got to get pay up for Department of Corrections. Well, it seems to me like something has to be done to get the pay up for attorneys, because otherwise you're not getting good representation. So with all that, any comments?
Well, we did have discussions in our subcommittee because we talked about the flat rate for GAL and TPR cases, and that might be okay for cases that aren't contested. And I know that Judge Dickinson said when there's a more complicated case, they're paid more, and that's just the average in Harrison County that they normally see. But we did talk about the fact that GALs, you don't want to discourage people from doing GAL work because it is very important work. So they need to be paid for their services, and they need to be able to do a good job and not worry about the number of hours that they're putting into it. I wish I had a solution for that or an answer for that. I don't.
But I can tell you right now, based on what I've seen, we are discouraging people from doing GAL work. And I see people nodding their heads. I mean,
That's true.
So it may be Judge Dickinson has some ideas, but I also think maybe judges see this on a daily basis, but when you're out practicing as an attorney, you've got a lot of expenses and time and stuff like that. So anyway, that's why we need to be talking. So
Right.
I think
Judge Hudson?
Just to be clear, I'm relatively confident I've said this, but just so we understand, when I'm talking about is TPR cases, that's the flat fee. Now, I do not do that, obviously, on the protection side, while these cases are going through as an abuse neglect case. I am a huge advocate of having a full-time guardian ad litem on staff at youth court. I think that eliminates the pain concern that you have, and perhaps maybe it's something that I'll look at on the TPR side. Of course, if we have some sort of change that provides that whenever it's possible that the guardian ad litem will serve as the guardian ad litem on the protection case, also continue forward and serve on the TPR case, you may just solve that problem if they're on staff. So that, I just want to make sure that was clear that what I'm talking about is strictly the flat fee is just paid for the guardian ad litem who served on the termination case.
yeah, and I will say the ones that I've seen that are permanent, so like in Jackson County Youth Court, yeah, permanent, that does seem to work, but that means their focus is on GAL cases and not on everything else that goes along with that. And it does seem like you get a better representation.
I believe, Judge Hudson, you had a comment or a question?
I did. I can, and of course, the problem is in the urban counties like Jackson County and Harrison County, Hines County, Rankin County, Madison County, those are possibilities. But in the rural areas, there's very few full-time. I don't think there's any full-time guardian ad litem. So I think it is important to establish some type of reasonable pay scale that they must, it shouldn't be something that is negotiated county by county. There should be some reasonable pay scales, and you will pay this amount of money for Garnet Items and other folks that have to serve in the youth court. One other comment I had about the statement of the kids knowing whether or not they had the right to get a lawyer. I know that some time ago I was at a conference and I was invited to go over to a CPS conference with their older kids that were aging out. And there must have been about 20, 25 kids there. And I just sat in the background and listened for a while. And I was absolutely totally wiped away by the fact that they seemed to have no connection to the court at all and had no belief that they had a right to connect to the court. And these were 17, 18, 19-year-old kids that were that were about to age out of the system. And I told them that day of the new legislation that made them parties to the case and call their judge and tell them they wanted an attorney, and he or she had to appoint an attorney at that point. But I think we probably need to also, I believe that since that law passed, that the court should every hearing they have remind the kid that if they feel like there's a conflict, that he or she will appoint them an attorney, and not just assume that kid's going to remember that from a hearing that he or she advised a year ago. It should be something that's advised every single court session, because kids don't think more than 48 hours in advance. So, I mean, that's gone. That's flown out of their mind, and now they're wondering, how can I talk to the judge? I never get to talk to the judge. I can't talk. But they don't remember something that what they were told 3 or 4 hearings ago. So it should be repeated at every hearing so the kid knows that, yeah, I want my voice to be heard.
Well, based on Chairman Wiggins' comments, and Judge Pierce, I'm cognizant of the fact that you still have some other issues to present your recommendations on, and this may be something that you cover, so I'm not trying to get ahead of your presentation, but do we want to think about a statutory increase or some sort of increase? I'm just throwing that out there for consideration for the GALs, for the terminations, and what does that look like? And do we set some kind of minimum threshold?
Madam Chair, I like what Judge Hudson said, which is a scale. And it sounds to me like there's different levels between youth court and chancery court matters and all that. I kind of look at it as like the GS scale in federal, GS 1, 2, 3, 4. And like that, also like guidelines on the sentencing guidelines. So I like that idea, and whether it needs to be mandatory or advisory is a question to be had, but seems to me like it would help. And what we're hearing from Commissioner Sanders is that it's different all over the state. Mm-hmm. And if you do what you're kind of suggesting, then you put it into it's at least in there, and everybody in the state can see it as consistently.
I had just a brief comment, because it's not, and it may lead into the next topic, but it's not only a GAL problem. It's an all-youth court practitioner. I know parent attorneys, they get paid $50 an hour, and they do it because they love it, not because they're losing money being paid $50 an hour. But they do it because they love it. But when you hear GALs, parent attorneys, prosecutors, judges, they do it because they love it. But they're almost all losing money doing it.
I guess I would ask the question of Judge Pierce, would y'all be able to develop basically a pay scale?
I think a pay scale would be helpful. What that looks like, I don't know what GALs make in the counties that have full-time, and I don't know what typically gets paid I know what happens in Greene and George County, but I don't know what happens in the other referee counties or county courts. But I'm willing to work on that. I'm sure that our subcommittee would be willing to do that. I did want to say that I had highlighted, and I didn't read it off, but I should have, is that the role of the GAL is very demanding and requires individuals committed to protecting the health, safety, and welfare of the children. So they have a very important role, and they do need to be paid for their time, and we don't want to discourage people from serving as GAL.
Commissioner Sanders?
I would actually add to what Judge Pierce said, and that is that it's been a long time since I've been in Chancery Court, so I'm not going to speak to the complexity of the matters that GALs would handle there, but the notion that the matters that have to be handled related to whether or not we permanently remove a child from their parents' home or take them from the home to start with, and then weigh the harm we know we're doing to that child when we take them versus the risk of leaving them there. I don't think you can get a more complex, nuanced decision that has to be made in a court. So I think it's really important that we elevate in all of our decisions that this is not a secondary, mundane decision. This is a life-changing, I think it has liberty interest. It implicates fundamental rights under the Constitution. So I encourage that we treat it like a real court proceeding, and that we have the proper parties present and represented, and that we treat GALs the way we would in any other complex decision-making matter in the court system.
Based on, Commissioner Sanders, you talked about some of the difficulties that you're having with getting invoices. Is that something that we need to make statutory?
I think that could help. I need to talk to my financial people, and I can get some more information. Judge Pierce, we've been working with Subcommittee 3, but I need to know a little bit more about the trends we're seeing. But yes, some kind of or standardized form that we implement, but having statutory backing on rates and requirements, expectations, and duties would be very helpful.
It would be helpful. That was going to be my next question too. Not that we're trying to tie the GAL's hands, but do we need to set some threshold for the number of meetings that should be held?
I would defer to some of the people who are in court on a regular basis. I think every case is different, and that's hard to say, but at a minimum, they need to meet the child in advance of court, and they need to interview the child independently from CPS in advance of court.
If I may on that, Madam Chair, that I think built in, if there was actually more pay, that would ensure more meetings or that, because then the attorneys are looking at it that way. That was kind of my thought about that.
Let me just add that the Judicial College has drafted proposed standards of practice for guardians ad litem that outlines a lot of these duties that I'll be glad to circulate that to everybody to see, and that might be something we should consider proposing to be adopted here. It just occurred to me just now that we haven't it already, and we can certainly consider that and may address some of the issues about, well, what exactly is the guardian supposed to do? And so those standards, and they're not final, so we can always tweak them and add to them. As far as explaining to the GALs, not just in the TPR cases, but what they ought to be doing in every protection case, what you ought to be doing in every chancery case where you're appointed to provide zealous representation to the child.
And Judge Pierce, I would be more than happy to assist with taking a look not only around Mississippi, but around the country to see what guardians ad litem future things. I like to phase billing, depending on how much work is done on the case. For instance, phase one may be the detention hearing and up to the plea. If they admit their administrative disposition, we don't think I'm going to trial. We're going to trial, they go to phase two, that kind of thing. So that may be something else that we want to look at. But I'm more than happy to assist in helping you look at what guardians are allowing to pay around Mississippi and around the country.
So, Madam Chair, in the interest of time, and it sounds like we have it, I would make a motion with, after hearing all that, that this subcommittee investigate and report on a pay scale along with the duties that are required at different levels of GAL work, and then report back before our final meeting.
Absolutely.
Okay.
All right.
Is there a second?
Second.
You've heard a motion and a second. All those in favor say aye.
Aye.
Are there any opposed? All right. Judge Pierce, you're recognized.
To our second topic that we were given to look into and study was to review whether parent representatives should be provided, and if so, how to pay them, and whether Title IV funds can be used to pay them. And we unanimously said yes, that parent representatives are needed in all abuse and neglect cases in youth court, and should be involved from the beginning of each case. And a little background, in January of 2017, the Children's Bureau issued an information memoranda which encouraged all child welfare agencies and jurisdictions to ensure high quality legal representation to all parties in all stages of child welfare proceedings. They went on to say that the quality legal representation in court is an essential safeguard to ensure that pertinent information is conveyed to the court, all parties' legal rights are well protected, and the wishes and needs of all parties are effectively voiced. In turn, it helps the judges make the best, most informed decision possible in every case. And I set out some benefits that they listed for having a parent representative. Legal representation can also help develop effective plans by more accurately identifying the needs of families and ensuring those services are tailored specifically to them. And CPS has been diligently working to obtain the maximum reimbursement for parent legal representation, and did provide a timeline of their efforts on the topic, which I did include in the report. So there's a copy of that timeline in there if you want to look over that. And then I also provided a copy of parent representation in child abuse and neglect proceedings and requests for appropriation that Judge Hudson had prepared for the legislature in 2021 that sets out some numbers and statistics for the 12 parent representation pilot counties that had been operating continuously from July of 2017 through 2021. And the Office of the State Public Defender strongly advocates for mandatory appointment of counsel to every parent facing the removal of a child from their home who cannot afford private counsel. In a letter provided from OSPD, it is noted that based on research and the experience of the pilots, having attorneys in these cases not only protects the fundamental rights of parents, it helps move cases through the system more quickly, reducing the time kids are in foster care, resulting in savings to the state to offset this new expense. For example, during the 2022 calendar year, CPS saw a decrease of children in custody from 3,849 to 3,673, which is a decrease of 4.2%, while those counties that were represented by parent defenders saw a decrease of 6.2% of children in custody in those counties. OSPD has concluded that the ideal delivery model is a full-time parent defender in a legal aid or defender office with access to clerical and social service support. And the estimated cost of funding the parent defense and child welfare matters is $3.3 million. And today the funds from all of the sources available cover less than half of that need. And the subcommittee also felt like youth courts should readdress whether counsel should be appointed when the parents are having trouble complying with their service plans, regardless of their eligibility. This is especially important at the youth court level because the parents' failure to substantially comply with their service plan may be used as grounds for TPR in a subsequent TPR proceeding. So we looked at or reviewed the Title IV-E funding to determine whether funds are being legally maximized and how they're being used, and whether there are changes that need to be made to get the most out of those federal funds. And I put an explanation in here that Judge Hudson had provided to us about what are Title IV-E funds and what the goals and the requirements are. And I'll just briefly, Title IV-E funds are federal funds provided to states to pay a portion of foster care payments for children who are eligible. Federal dollars pay a majority of the cost. Federal law requires prerequisites to exist before reimbursement. If those are not met, the state will be responsible for 100% of the foster care costs for eligible children. The receipt of the Title IV-E funds is contingent upon an approved public assistance cost allocation plan that outlines the procedures to identify, measure, and allocate costs to all programs administered or supervised by the state agency. Mississippi Department of Child Protective Services submitted its cost allocation plan to the federal government on June 29, 2023 for approval. And the primary goal of the Title IV-E of the Social Security Act is to support children who are under the care and custody of the public child welfare system. The purposes include reducing the number of children who are removed from their homes and placed in substitute care, improving the quality of care of children in substitute care, and to return the children to their homes as soon as the conditions of the home allow, and facilitating adoption or other permanent placement for the children who cannot be returned to the home. And I set out the requirements that have to be met for a child to be eligible for IV-E funding. And the reimbursement is based on the state's penetration rate, which is the percentage of children who are IV-E eligible compared to the total foster care population in the state. And currently, Commissioner Sanders told us in a meeting last week that the state's penetration rate is at 42%, which is up from 35% in March of 2022. And I did attach a graph that shows the change in the penetration rate over the last few years. So under the formula, the state can only claim reimbursement on 42% of actual expenditures. Then the reimbursement rate allowable for administrative costs is 50% of that figure. Our reimbursement rate at present is 21% of what was actually spent. Some states' penetration rates are at up to 75%, so a higher IV-E penetration rate increases the federal share of program costs. And you'll see the example that CPS provided, that out of $100 at 42% penetration rate, it's a $21 reimbursement. And then what it was in March of 2022 was 35%, was $17.50 out of every $100. So one barrier that we had in Mississippi to increasing that penetration rate a few years ago was due to court orders not having the necessary language or findings that are required in the youth court orders for cases to be eligible for IV-E funding. If that language was not in there, there was no way to remedy that by going back and correcting it. So it has to be done at the time those orders are entered. So with modifications to My Kids and additional training and oversight for the judges and referees, these issues have almost been completely resolved according to Judge Hudson. So what can Title IV-E funds be used for? All Attorney General fees spent representing CPS and child welfare matters, all CPS legal fees representing CPS and child welfare matters, matching county funds to the funds provided by OSPD, parent representation in those counties not covered by OSPD, local county funds expended to pay prosecutors in the responsibility to represent the state in child welfare cases. This would, however, require prosecutors to keep up with a percentage of time that's spent on the child welfare cases versus other types of cases. Local county funds expended to pay attorneys for the children when appointed in addition to the GAL. Reimbursement of funds paid by counties would require a mechanism to funnel the monies through a central agency or cede to the central agency the right to seek reimbursement for those funds. There would have to be an accurate accounting of time and payment for those services on the child welfare side. Accomplishing the reimbursement would further require a mechanism for the counties to transfer that payment to an organization like AOC to pool and then enter into a memorandum of understanding with CPS. And as Justice Beam's memo pointed out, the exploration of accomplishing this began a couple of years ago, but has remained dormant for a couple of years after the decision to transfer all parent representation activity to OSPD, and that discussion and research can be restarted. So that's what I have on the parent rep and 4E funding of that, and some other legal fees in youth court. I'll see if there's any question or comment. I know Judge Hudson knows way more about 4E funds than I will ever know, so if anybody has any questions on that.
I had a question, not necessarily on, for you or for Judge Hudson, but Commissioner Sanders, I was wondering, we can track through my kids, the timeliness of our hearings, and every hearing in youth court is on statutory timeline. Do we have the ability, I guess the CDS has the ability to tell me what Harrison County's penetration rate is, so that if I have some areas to improve, that I can make those improvements?
Let me investigate that, Judge. It's calculated across the state, but I think there should be a way to break that down. I will say, and I apologize for leaving, I have a budget meeting on 2 that's going to supersede this, and not much would, but 4E funding is peculiar, and there's an art to it. And we have really majored in it for the last 3 years. The notion that children need to be eligible to be protected from their parents is very foreign to me. But getting the orders right, but also getting the efforts right. The order is a finding by the court that we did make reasonable efforts, and so we're working internally on that. And Judge, I will investigate whether I can break our data down like that. There are also some, like I said, it's an art. Some things the agency hadn't done in the past, like when the parents' rights are terminated, then the child becomes indigent. So they can be added back into the rate. So there is room for Mississippi to continue improving, but we could not reimburse for attorney representation. We tried to get approval for it under the old cost allocation plan, which was a blended plan with DHS. That was one of the many reasons it was necessary to go ahead and sever the agencies so that we could submit a cost allocation plan that strategically attempts to set Mississippi up to draw down every $4E it can. I would again remind you, though, that even with this is the highest penetration rate Mississippi's ever had, for attorney representation, we would draw down $21 for every 100 we spend. So as I said to Jennifer, you buy 4, get 1 free, or 4.5, get 1 free. So it's not a lot, but so keep in mind, it would not supplant state funding. We would still have to have state funding, but we can match state funding that goes to OSPD, or we can match county funding. We have to have certification that it's not otherwise being used to draw down federal funds, and it has to meet certain requirements. I have to have documentation if I pay an attorney, or so pardon me for leaving early, and I will certainly try to come back if I can get done with this meeting.
I can tag team on,
Judge Hudson.
I can tag team on what the commissioner just said as well on 4E funding. It's not a panacea. It's not a great amount of money, but it is money that we don't use right now, that we don't pull down right now, and we need to pull down. Right now, she's talking about it's at $21. If we could get it up to $50, that would go to $25, and so forth. The further up we can go. In 2017, the penetration rate was 28%, and now it's moved up to 42%. That's a huge increase over the last several years, and it can be used. Now, there is a agency that we've connected with, that I'm going to connect with Commissioner Sanders, that the most difficult part of pulling down that money is pulling down the county contributions. It's easy to come up with the amount of money that OSPD pays for it, or that the Attorney General pays for child, but the counties, you're talking about the GAL, and a lot of times you have a GAL also substitutes as a defender in delinquency cases, so they too would have to divide their time between what they spent on child protection cases for clients that were eligible for e-monies, and how much they spend on delinquency. Well, there is an organization that we ran into at the National Conference of Juvenile Family Court Judges who basically do this for you. And they're doing it. They're working it in Georgia right now, where they go and they train all the county staffs on how to meet all the federal regulations as to what was actually used, and they pull those monies and send those monies to the state level, and the state is able to pull down on that. And they, as a lawyer, we all know what contingencies are, and they are paid on a contingency basis. They don't ask for any state funding or anything like that. They're paid about 10%, 7 to 10% of what they collect, which is a pretty good deal when you're talking about the intricacies of 82 counties, figuring out what monies they spend can be matched. There is another pot of 4E money that's not connected to all of this, and the commission didn't talk about that, but I'm glad to say that the CPS now is really pursuing that 4E money. That's money that's been made available by the Family First Protection Services Act that came down some, I guess it was 2018 when it passed. And if we can provide acceptable services and over that, we'll get a 50% match. And that's infinite. As much as the state would put into prevention services, there would be a 50% match from the federal government for those services. And I understand that CPS is working on a plan right now to access those 4E monies as well.
Thank you so much for that, Judge Hudson. Were there any other questions or comments? Seeing none, Judge Pierce?
So another topic that we were given to look into was to review the Fatherhood Initiative proposals and develop proposed policies to increase fatherhood participation of absent fathers. And in reviewing Fatherhood Initiative programs, we looked to some other states, which included Connecticut. According to their website, the Connecticut Fatherhood Initiative, CFI, is a broad-based statewide collaborative effort led by the Department of Social Services focused on changing the systems that can improve fathers' ability to be fully and positively involved in the lives of their children. Connecticut was the first state in the country to pass legislation on fatherhood. Their work reflects the overarching objectives outlined in their initial legislation, which were to promote public education concerning the financial and emotional responsibilities of fatherhood, assist men in preparation for the legal, financial, and emotional responsibilities of fatherhood, to promote the establishment of paternity at childbirth, encourage fathers, regardless of marital status, to foster their emotional connection to and financial support of their children, and establish support mechanisms for fathers in their relationship with their children, regardless of their marital and financial status, and to integrate state and local services available for families. And I did attach, or at least the link is listed in here, to an article that I located. I know it was in May of 2018, but I thought it provided some useful information on different programs in different states. And we talked about the fact that it's important for CPS to establish contact with non-custodial fathers from the outset of the youth court proceedings. Diligent efforts must be used to contact an absent parent, often the father, from the beginning of all youth court child protection cases. And one suggestion that Professor Calder had, and he may want to speak to this, but to consider amending the DHS child support enforcement statutes to allow courts to establish minimum child visitation schedules for non-custodial parents if visitation is in the best interest of the child when child support is ordered. And I did see that many of the programs, fatherhood initiatives and programs throughout different states are administered by the state's child support service divisions. So when reviewing the fatherhood programs for possible implementation in Mississippi, research evidence of effectiveness is important. According to the Results First Clearinghouse database, 2 fatherhood intervention programs have received the highest ratings for evidence of effectiveness. These programs had positive impacts based on the most rigorous level of evidence and therefore could be potential candidates for implementation in Mississippi. The first one is the Supporting Father Involvement. This program is for parents of children ages 0 through 11 and is preventive intervention designed to enhance fathers' positive involvement with their children. The curriculum is based on an empirically validated family risk model which targets 5 aspects of family life: quality of relationships between parent and child, and highlights the potential contributions fathers make to the family. The program lasts for 16 weeks and includes 2 hour-long weekly group meetings, and the program is typically conducted in a community-based agency, organization, or provider. And the second was Parenting Together Project. This program is an educational intervention for first-time parents that focuses on the development of fathers' knowledge, skills, and commitment to the fatherhood role. The program's goals are to increase mother support and expectations for the father's involvement and to foster co-parental teamwork. The program consists of 2 8-hour sessions spread out between the second trimester of pregnancy and 5 months postpartum. Proposed policies to increase fatherhood participation of absent fathers could include a requirement that any fatherhood program implemented in the state must have research evidence demonstrating its effectiveness.
Very good. Very good. Are there any questions or comments for Judge Pierce? Seeing none.
We did have a few other items that we looked into, and I'd asked Professor Calder if he would talk about the review of termination of parental rights process, as well as some other issues to consider to improve foster care and TPR. And then Lindsay Simmons is going to speak a little bit on her experience as a foster parent, some thoughts that she has on foster families and that she's experienced in working with other foster families as well. So I would like to recognize Professor Calder to talk about the TPR process.
Professor Calder, you're recognized. We can't hear you, Professor Calder. I think you're muted.
Sorry. Thank you. Yeah, these are issues that just come up in my own practice, just things that I had experienced or observed, and I wanted to take the opportunity of having our committee together to at least raise them. I don't want to get too much out of our lane, but as far as the TPR statutes are concerned, I think that there's an inherent conflict in the grounds that are set forth in section 9315-121, subsections A and B, which the first subsection talks about a parent being diagnosed with a mental condition, and the standard there is that the parent is unwilling or unable to provide an adequate permanent home for the child. The second subsection B talks about a parent who has some kind of physical incapacity, and the standard there is that it prevents the parent, despite reasonable accommodations, from providing minimally acceptable care for the child. And to me, both of these statutes implicate the ADA, and I think that the standard set forth in subsection B is the standard that should be applicable to both sections, both the mental disability and the physical incapacity. And the way again, just speaking anecdotally, I've seen situations where someone with mental incapacity is completely precluded. In other words, they're terminated because they're unable to provide an adequate home, permanent home, even though they might be able to adequately care for the child just for visitation purposes. So I think that there should be some consistency there in the standards for termination between those two sections. But again, that's just my observation about that. And I was on the committee that drafted this, so I accept responsibility for being part of the problem here, because I should have paid more attention to it when we were reviewing the statute. the criminal code requires there to be elements of the offense. So, the reason I think that it's important, first of all, is for criminal prosecutions, it's essential, but also this statute provides a basis for terminating parental rights under Section 121H.5. So if a person has tortured a child, their rights can be terminated, and it provides a standard for finding aggravated circumstances in youth court that would justify bypassing reunification. If there's been that conduct by the parents. So, right now, the only real problem is the prosecution of the criminal statute. No one has challenged it under the other statutes, but I think it would be appropriate to adopt a definition of torture that could be applicable for the felony child abuse statute, and also also in the TBR action and in the youth court proceeding. So what I did, there's actually an ABA resolution that was adopted by the ABA in January 2019, and apparently we're not alone in this problem. And the ABA was recommending that all states adopt some uniform standards for felony abuse based on torture, and they have in the resolution they set out the different variations that exist, and I just took the liberty of drafting a possible definition that we could consider that would, I don't want to go read it out loud, but this would potentially be a definition that could fill in the gap there that we have currently. I intentionally made it a little bit broad in the sense that it involves torture involves treatment that is intentionally cruel, inhuman, and degrading, and then they included but not limited to, and they gave examples of the kind of cruel, inhuman, and degrading conduct that would be considered torture, and so that would certainly be open to adding any other kinds of conduct that might be appropriate. But this is on page 12 at the top of the page on our report. So that was again just a problem that I've seen in the statutes that I thought maybe we could include in our ultimate recommendation for how to improve the TBR provisions in our code. The other issue that had come up that I had seen in other states, and again, I'm glad Commissioner Sanders isn't here right now because I don't want to step on any toes, but a lot of states, currently, if a child is eligible for Social Security payments while they're in foster care, those payments go to CPS. And CPS uses those payments for the care of the child while they're in custody. And a lot of states are taking the position that really isn't the fair way to do this. I don't know if there's any legal arguments to be made to support that, but a lot of states are taking that money and putting the Social Security payments in a trust fund for the child, which then would be payable to the child when they leave custody as a nest egg, some funds that would be available to the child to transition out of custody. And since that's kind of a big issue that I think we're dealing with in our system at present, it seemed like that could be a way to help children make that transition when they have those funds available. And personally, I think if the state is going to take children into custody, the state should be responsible for providing for it, for their care while they're in custody. Again, that's just another policy consideration. The other concern that I have that I threw in here is that as a practitioner, I have been confused about the time, in the past, I think I've got a handle on what the current state of the law is, about the timing for appeals from youth court. And I think most practitioners who come in occasionally and aren't totally familiar with the case law that has established these rules don't realize that if you, well, let me just say that the current rule is that you have to appeal each discrete order that the youth court enters in order to reserve any challenge to the validity of that order. So for adjudication and disposition, if you don't appeal that decision within 30 days after the order is entered, you can't challenge any of the findings that went into that order at any later proceeding. And so, for instance, a parent would come in to court, have a child removed, they go to adjudication, disposition, child's placed in care for a period of time. The parent may not be able to meet the service plan and ultimately have the case referred for TPR. And the case law currently holds that if you wait until the TPR proceeding, or if you wait until the youth court case is terminated, or until the TPR proceeding begins, you cannot go back and challenge the underlying facts about whether reasonable efforts have been provided to the family before the child was removed, reasonable efforts have been provided during the reunification period. You have to have appealed all along the way in order to preserve any of those issues. And so that's the decision. Those are the decisions that the Court of Appeals has issued over the last 2 or 3 years. And it's not in the rules anywhere. There's nothing in the youth court rules that explain what is a final order, a final appealable order that should require an appeal if you're going to preserve the issues that have been raised. And this really came into focus when I became familiar with the EK case from 2018, which is a Supreme Court decision. And in that case, the court went all the way, the youth court proceeding went all the way through to reunification. And the child had actually been returned to the family, and then the parents appealed what had happened in the youth court because they didn't like the fact that they had been, adjudicated to be abusive and neglectful parents. And the Supreme Court considered all of the issues that had been raised by the parents in the EK case. So it seems to me that I read that case as being in conflict with the decisions from the Court of Appeals, and certainly it would welcome anyone that can reconcile it for me. But it just seems that we need to clarify exactly what is an appealable decision from the youth court and make it clear in the rules about what becomes a final appealable order that you're gonna waive, or it's gonna become res judicata if you don't appeal it timely. Then the next point is we have a new statute that specifically provides that durable legal custody. When a youth court grants durable legal custody, the youth court retains original and exclusive jurisdiction of all matters related to durable legal custody, including but not limited to petitions to modify durable legal custody. And first of all, I think that's a good statute in the sense that it clarifies a problem that I have seen in many youth courts where once durable legal custody is granted, the court just closes the case and nobody ever reviews it again, which is not, I don't think, what the rules require. But now this statute specifically says exclusive original jurisdiction retains in the youth court, and the problem is how do you have any kind of parallel proceeding in chancery that would go to TPR and adoption if you've had a durable legal custody order how do you reconcile the two? And at this point, we don't have a clear uniform rule that allows for transfer of jurisdiction from youth court to another court. Our Rule 23 talks about, in child protection cases, our Rule 23 of the youth court rules talks about transfers for delinquency, where a child who is technically eligible for youth court is transferred to circuit because they're going to be prosecuted as an adult because of the seriousness of the crime, but it doesn't have any provision for transfer on protection cases. And but there is a process for doing it that's set forth in the case law. So the Supreme Court has explained in several cases that they've decided that the youth court can voluntarily relinquish its jurisdiction to Chancery Court when there's a parallel proceeding that will result in permanency for the child, like TDR and adoption. But it's all in case law. It's not clear in the rules anywhere, and you have to kind of research the issue to find these cases if you have that situation. I'm not 100% sure that these cases even still apply now, given the amended statute that provides that original exclusive jurisdiction provision. So it just seems that there's some need for clarity on the transfer issue, where the youth court has pretty much done everything that they intend to do. They've made a permanent, as permanent as it can be, placement with an appropriate custodian, but now the custodian may even be the one who wants to, and very likely is the one who wants to go to Chancery to adopt, but it seems that there may still be a hurdle because of the way the statute is worded. So I thought that needed to be addressed. And then finally, our definition of neglect. Judge Pierce, did you want me to go on and talk about this now, or do you want to?
Yes, sir, if you don't mind.
Okay. Yeah. Our clinical program at Ole Miss works for a year or so with the Casey Foundation to try to revise our definition of neglected child that would basically afford more opportunity for children to be, children and families to be assisted when the source of the neglect was really a poverty-based issue. And as we all know, neglect is, 75% of our cases. So when the problem is simply that the child is living in a home that doesn't have electricity, rather than removing the child from the custody of the parents, the first step should be providing resources to the family to try to retain the child in the home when that can be done safely. That's required. That's our reasonable efforts requirement that we have to meet anyway. But the way our statute is written, currently, there's different definitions about what a neglected child is. But we have a provision that says, the first part says, a neglected child is a child whose parent or custodian, and this is on page 15, about two-thirds of the way down, a parent who's responsible for the child's care or support neglects or refuses, when able to do so, to provide proper and necessary care. So there's a little hint of, poverty shouldn't equal neglect. And just because the parents have inadequate resources at a particular moment in time. But the current statute includes subsection 4, which really subsumes everything else, because it says a child is neglected if for any reason they lack the necessary care for their health, morals, or well-being. And so that's kind of the default, I think, in many cases that we're working from, is that if there's any lack of resources, then subsection 4 requires the child to be that hearing to be conducted to determine whether the child's neglected or not. So our clinic surveyed the states that had moved away from that really kind of stringent definition of neglected child and incorporated different language from different languages designed to recognize that the first step ought to be trying to provide the parents with resources so that they can fix the immediate problem, and so that there's no risk to the child's health or safety. And so we came up with a definition that said that a child shall not be considered neglected based solely on the failure of a parent or caretaker to provide the child with food, clothing, or shelter necessary to sustain the life or health if the failure results, the failure is caused, we got a typo here, if the failure is caused solely by the financial inability or lack of resources of the parent, unless available resources to relief services have been offered and refused. So that was the simple version of what we had proposed to try to build in a more opportunity for CPS to provide prevention services, which I think is, Commissioner Sanders has indicated that's certainly the administrative policy changes that they're in the process of making now, and they're funneling more money into the prevention of removal than they ever have before. And so, and all of this is consistent with the federal requirements that we have to follow in operating our child protection system. So that was the language that the committee considered and included just as a simple way of trying to build in this option for not taking every child into custody because the family's poor and they're in an immediate crisis that may be able to be resolved if they just have the right resources provided to them. What I realized after we had made that final decision is that I wanted to include the rest of the option that our committee really hasn't given full consideration to, but there was some alternative language that we had included in our original proposal that defined a child in need of assistance, and that really went into more detail about a child in need of, defining what a child in need of assistance was to give more substance to this. But as I said, our subcommittee hasn't addressed this fully. But if we're gonna make a report back on anything, I would ask to be allowed to present this more fully to the subcommittee for reconsideration. It was in our original proposal, but I think we wanted to try to simplify everything, and maybe we simplified it a little too much, because I think this explanatory definition about a child in need of assistance would be essential to really putting substance to the goal we're trying to accomplish, that being, don't remove a child from a family just because they're poor. Try to help them first, provide the resources that they need, and as long as they're being monitored and the child is safe, without, and some administrative changes that are underway at CPS. So that's what I want to do, is talk with Commissioner Sanders further about this and get their input and approval of anything that we did in terms of defining that child in need of assistance.
Professor Calder, what I would recommend, because we have one more meeting left in November, our recommendations are due on December 1st. What I would recommend, in the interest of time, and obviously you and your subcommittee have already input a lot of time and research in the recommendations that you made, is in advance of the next meeting that we have in November, perhaps if you mentioned that you wanted the opportunity to talk to CPS, that you're able to get with CPS and then email us whatever consensus or recommendations you and Subcommittee 3 may have, because as we get further down on the agenda, and I try to have y'all out of here at 2:30, because I realize that everybody has duties and schedules, and you're taking away time from your other duties to be here, and we, both Chairman Wiggins and I, appreciate that. I would suggest when we get a little bit further down on the agenda and we start talking about how we proceed with the recommendations, that would be helpful. And again, kudos to you and Subcommittee 3 for looking at these additional items for consideration. Council Tatum and I were looking, and we discussed this for our first meeting, is that when the House and Senate, when we came with this bill, with the Senate bill, there is a caveat that says if there were any other issues that the task force deemed appropriate that they could consider, that we can consider that. So thank you for looking into these extra considerations and items of concern.
Sure, glad to participate.
Are there any questions of Professor Calder?
Can I just make a statement about the last thing he was talking about? The Commission on Children's Justice, which Justice Beam is, well, I think she's gone now, but is one of the chairmen of, some 2 years ago created a task force on the definition of neglect, because that's a national thing that's going on, basically looking at the fact that we've almost criminalized poverty with our definition of neglect. So we want to look at that, and they created a task force of about 20 people involving CPS and everybody involved in the system, and they met, and the University Law School was the researcher arm of that task force and put together a report, and they adopted that report on what the definition of neglect should be. And that's where Professor Calder is talking about a child in need of services. The whole idea, so we can understand where we're coming from, is that the system as it presently exists, you don't want to use the word criminalize, but it actually does. I mean, when somebody comes to your door and says, I'm from CPS, I'm investigating a report of neglect, that basically criminalizes their existence. And if that reason why they're being investigated is connected to poverty and nothing else, then they are basically being investigated because they're poor. And our state law right now, as we exist right now, says we can't do that. That's not the purpose of CPS. It's not the purpose of these investigations. So we took that together and said, okay, let's divide the systems. One system that's a help system, one system that's an investigatory system. Both of them would respond to the needs of the kids based on what those kids needed. And CPS has already devised a program where they're now, when they take the 1-800 number, where they're assessing the calls, where they're actually sending those calls that they think are poverty related to a different part of CPS. This particular program basically calls those kids children in need of services. And a different person, not an investigator, goes to that house to say, hey, we understand this is going on in your life. We want to bring some services to help you deal with that situation. And so they're there. Now, if they say, get the heck out, we don't want to do anything, then that then turns into an intentional neglect. But if they say, well, thank you, let's work together, then those children will be served, but their family won't go through the trauma of being investigated for having intentionally neglected their children in that situation. And it works very well into the process that CPS is putting together right now, where they're separating those responsibilities between investigatory and help. We've already passed this definition. I don't know that David knew this. We've already passed this definition by the commissioner, and she really liked the definition that we passed by the commissioner on this. And this would basically create a black line between the two and have representatives of CPS whose job is only to help and to seek to help those people, and that if those people don't receive their help or refuse their help, then they turn it over to another division totally unconnected to them that comes in and does the investigations. So that report's been done and been accepted and been actually referred to the legislature once, and it was actually done. You might remember a couple of years ago there was a legislative request to the commission to do these things, and it passed the House, it didn't pass the Senate, but we did it anyway. This was in response to that.
I remember the report, and Justice Beam, during the second meeting, she talked extensively about the report and some of the very sentiments that you just mentioned, but I do remember the report very, very well.
So we believe it's a great definition. It'd be great for Mississippi to make a move like that, because that would put us, and we're already on the front line a lot of child welfare issues right now. Mississippi's been referred to as the Mississippi Miracle because of the great reduction in kids in foster care. This would just put us even more out in front nationally about dealing with the issue of kids that are being removed because they're poor.
Well, and I think everybody definitely understands Professor Calder's concern in wanting to talk to CPS just to make sure that we're not stepping on any toes. So we'll look forward, Professor Calder, to getting your additional recommendations in advance of the next meeting. That way everybody has a chance to consider them. I'm going to recognize Ms. Lindsay Simmons right now.
Thank you. I apologize to my committee because I'm woefully unhelpful. I'm not a judge and I have not practiced law in years, so they were all much more versed in these issues than me, but I appreciate them letting me have a chance to share. I'm on this committee as a foster parent, but in my lobbying work, I do a good bit around human trafficking, domestic violence, and sexual assault, which overlaps a lot with the foster system, and I also founded an anti-human trafficking nonprofit several years ago, and we've spent the last few years setting up a shelter for minor victims of human trafficking. So because of all those hats, I get a lot of phone calls from foster parents, people in the system, and I just kind of wanted to share some things. And thankfully, Commissioner Sanders has been an open door to me. I emailed her early on when she was there and said, could I please come tell you all these things? And she listened and has continued to allow me to come with my concerns, and I'm very thankful for that. And I do think they've put together a really good team up at the top of CPS, and they understand a lot of this, but the funnel down to social workers is not happening. And then we also have a lot of issues with judges, and CPS has no control over that. And so I just wanted to bring up some things. So Professor Calder explained much more eloquently than me the jurisdictional issues around durable legal custody. I have seen that work beautifully in kinship placements when people want that, but it is foster care purgatory, and children cannot get out of DLC when they are put in that, and families don't understand it. We talked a few weeks ago about how these social workers are doing the job of an attorney a lot of times and explaining these issues, and that's not fair. My suggestion on that would be to have some sort of written agreement that a foster family could sign if they're going to be given durable legal custody, to where they understand that they cannot adopt that child. We had a friend that this happened to. She did not understand that it was not termination of parental rights, and then when she got her order for DLC and was super confused about what it said, the court had shut the case down and would not talk to her. Her social worker would not talk to her. They could not find anyone to help them. They had to hire a private investigator and a private attorney. They found the mother of the child in rehab and went to her, and she signed over her rights just like that. There was no need for them to have durable legal custody for a mother who did not want that child and had already lost 3 or 4 kids to the system. So it is foster care purgatory. We certainly appreciate reunification as foster parents, which leads to my next point. Adoptive families, no matter how picturesque it may look on Facebook, those families are built on the grave of another family, and it's tragic. And as foster parents, we understand that, and we appreciate reunification, and many of us want that and want to help the parents of the children that we're fostering. My children were already TPR'd when I got them, so I did not face that situation, but I have many friends who are foster parents who are genuinely for the mothers. But when the mothers have no resources, you can't just keep on, with pushing reunification and not helping the mother. And then particularly if the mother is not showing up, like in my friend's case where she signed over her rights so quickly, she hadn't shown up in 2 years. So why are we still pushing it when we need permanency for these children? And I know there's mixed feelings even in this room and among different providers about that, but I just don't want to forget the true best interest of the child when we're talking about reunification, because that's not always in the best interest, even though we as foster parents understand that in an ideal world that would be great. It's just not always going to happen. So I like some of the timelines that we've seen in other recommendations about moving closer to permanency. But what we see is that CPS favors family reunification with any family member over foster care. And so you may have a child who's thriving in a good foster home, and they will find some obscure cousin or uncle who the child has never met, and they will quite literally rip a screaming child from a secure foster home to put them with a family member that they do not know. And they will call that reunification. They'll give them durable legal custody, and then that child is out of the system. And that's not always best. And so these are big picture things that I don't have a lot of, like we've talked a lot about good things and that can help, but these are just some things that I wanted to say out loud that I think are not being said. Every county operates differently, and so I've shared before my situation that my kids were from Hancock County. We live in Rankin County. We had all these social workers. Some counties, you can't even get a kid's haircut without permission. Other counties, they trust you to do whatever you need to do, and you report to them later, so it's very difficult to manage all of that. And my recommendation is to have some sort of grading system like the Department of Education has, and grade these counties and say, hey, if you're an A-rated county, CPS is out of your hair, you go forth and do a good job. If you're a C-rated county, let's talk to Judge Dickinson and get some ideas from Harrison and implement those and do better. So I think there needs to be some kind of uniformity so that all the counties can rise to a higher level, because some do a great job and some just don't, and it's super confusing for social workers, foster parents, everybody involved. For the social workers, we've talked over and over about how they're not paid enough, and we know that. And what I see from the human trafficking side is when a social worker gets called at 3 a.m. for a kid that's been trafficked, they're not coming, and you can't blame them. They're 24 years old. They're not making enough money to get up at 4 a.m. or 3 a.m. and go take a child that they have nowhere to put them to begin with. So there's some issues around that, though, that we need to work on, because I think Commissioner Sanders and her team understand that, but some best practices are just not getting pushed down to social workers. And one of the solutions to that, I think, is utilizing private agencies more. and where there's good private agencies doing good work, and we talk about that in the legislature all the time, like private companies and agencies can do things more efficiently than the state sometime, and if they're doing that on grant funds and fundraising and not even using state dollars for the most part, let's let them do their good work and not have CPS repeating what they're doing. You know, let's outsource some things to private agencies, which I think would take a lot off of these social workers and allow them to do better work on fewer cases. And then the last thing, we have quite a few children who are in hotel rooms right now because they don't have placements. They're being babysat by social workers. Most of those children, they're your they're your difficult kids. They're running away, and they're doing that because of their significant abuse. And so a lot of them are trafficking victims, and we have open beds in the trafficking shelter that aren't being used because it's a little bit more work to get them there. They need a court order. Social workers need to fill out some paperwork. They don't want to do that, and so they have these kids in hotel rooms. And I understand that at some point when there's no placements, you don't have an option, but we do have options, and so it's extremely frustrating to hear that these kids are still sitting in hotel rooms getting zero services. So that's kind of my spiel. And I will say about I should have said this earlier, the reduction in the number of kids in foster care, I appreciate that number has dropped significantly, but those kids, that's durable legal custody. They've been put in that purgatory, and yes, they're technically out of the system, but they're really not. And so they're going to be back. They're going to cycle back in. That's not a permanent solution in many, many cases. So.
I believe you have a question from Chairman Wiggins. You're recognized.
Thank you. Lindsay, I'm glad you've touched on the reunification because that's been my observations. And so I have I guess a two-part question that you say there's too much emphasis on the reunification, and that I think that comes from the fact that the statute says that's the default position. And you have these people carrying out that. And I've seen that where there are other, even, let's just say, non-family members who are closer to these kids than even the extended family member, and yet they're pushing to put them into the family members. And it has always seemed a problem to me. Do you think that's coming from the statute side of the equation, or what? Or where is it coming from?
I do, and I don't think the sentiment is wrong necessarily, especially if they're following the statute. But there needs to be some line in the sand or some flexibility or some common sense.
But the third cousin, just because they're a family member, doesn't mean they're a better place for the child over even a foster parent.
And I wouldn't call that reunification. When you put them with someone they didn't even know, just because they're family, that doesn't really count as reunification to me.
And I noticed that you said some judges favor any family placement over foster care to the child's detriment. I mean, you've seen that throughout there.
Yes, and I'm willing to talk specifically about that, not when I'm being recorded, but there are a couple of judges who are a real problem.
I've seen that. I think that's a problem.
Yeah, they just don't exercise good common sense, and that's frustrating. And then you have a foster parent who doesn't have has standing in the court, and so they can't even go really and represent themselves and defend themselves,
Okay, so my other part of the question, let me switch to the other side. Because what I've also seen is the law says there's a presumption for your parents, your biological parents, okay? But what I've witnessed at times is that foster parents tend to think those children are their children. And it ends up in a battle between the foster parents and the biological parents, let's just say. And it may be the reasons you're talking about. But legally, they're not their parents. So what's happening in those situations? Is it what you're talking about? And I've even seen it where the foster parents ran to adopt the children away from them over what the judge is doing. What's going on there? Because it's really confused me, I guess.
Yeah, and And I should clarify too, maybe not all foster parents are doing things correctly, but I think what you have is a highly charged emotional situation with the family who's usually had that kid from the day they were born.
Right.
And so they do feel like their parent, and that's all that child's ever known. And when they're 3 years old and mom gets clean and they say, now I want them back, it's extremely difficult for that foster family and for that kid. You know, the kid doesn't even know this lady. And so whether it's right or wrong, I think you just see a lot of emotions
Well, I think
around that.
that's a good example, because that's what I've seen it in. That's where the law meets what's going on, and the only basically parent that child has known since birth was the foster parent.
Right.
But the law says that the mom is clean, she's the biological mother, and therefore she has a right to that child, assuming everything else is okay. That's where the foster parents start fighting. How do we rectify that?
And if the statute maybe could say something, or maybe some of these things we've talked about with the timeline would help. If you're moving toward permanency sooner than 3 years, that might be helpful, you know, because this situation gets resolved sooner. But yeah, if the statute would just give some flexibility and allow judges to have a little bit more discretion, I think, which is
But
hard.
then you have judges who,
I know, it's a mess.
okay.
Yeah.
Senator Williams, I don't mean to interrupt. So currently, and I'm sure Liz knows this, but the statutes provide that if a child's in foster care for 15 out of 22 months, whether it's continuous or not,
It does.
then the plan should be termination of parental rights, and CPS shall file a petition to terminate the parent's parental rights. Lindsay's dead on point. I've seen it many times where you have a child who's been, as a youth court judge, every single hearing, I make a finding of whether or not the place that child was placed in is the most appropriate and least restrictive placement. Every single hearing. And so when you've got a child that's been placed in a foster family for 2 years, and now all of a sudden the plan changes to termination of parental rights, and then we have some cousin or uncle that comes through the woodwork and they want the child, well, then my will as attorney, is that what's best for this child? Because this foster family is where this child has been for the last 2.5, 3 years. And so I have a real problem with bouncing kids. I always say almost every hearing, I do not like to bounce kids from home to home to home. I would prefer to keep them in one home, in a home that I find to be the most appropriate and least restrictive. And if these family members or people who can't want to come through the door, they need to do that in the beginning of the case. Because I do not envision bouncing this kid from the place they've been in for 3 years just because we got a family member that came through. And the concern that I have, and this goes back, I don't want to get into this story, but it goes back to having these children and these families followed by one single judge and not multiple judges who don't know the history and how they're making these findings of most appropriate and least restrictive placement and what's best for that child. So I'm going to leave that there.
Senator, I just wanted to, first off, clarification on terminology. Reunification is reunification with that parent,
Yes.
not the family. So that's what reunification is. So
Yeah,
you
but-
threw me off using reunification with the family. But that going to the family just showing up, we have to be pushing a diligent search for family members in family visitation time. Because if there's a sister or a half-sister and they just never knew, well, CPS failed to find that sister and tell them, hey, your half-sister's in custody. So we have to start pushing that diligent search and visitation so that mom's not a stranger when we get to 2 years.
Yeah, and maybe y'all can answer this question. So like Lindsay put in her presentation, family placements are ideal in theory, and family meaning even the parents, but in reality, foster homes are sometimes better. And personally, I've seen that. The kids are in, let's just say, an economically better place, a better school district, a better thing, and then it's there, and they have to, and then they're returning the kid to the parent who are much worse off, if we're going to talk about the poverty situation. And then we get into this situation. So how is that fair? And how is that, should that be addressed? Because I've been in the middle of some cases where it's been argued, I can provide a better life, I got more money, it's a better school district, and you, judge, are going to return them to the parent who in the past has been a drug addict, and they don't have the jobs like we do. I mean,
The parent and child relationship is constitutionally protected as a liberty interest
Right.
by the Constitution. So whether or not they have more money doesn't mean that's their best placement. Kids need that family connection, and they have to know that they are wanted and that they belong. And as much money as a foster family can throw at it, that may not be what's best. And the Constitution and all federal statutes and most state statutes goes back to what is minimally acceptable care. Because you have to not be able to provide that to overcome that interest in a family relationship.
Judge Hudson?
And I agree with her to the extent, the whole point of the federal legislation is that the responsibility, when we find that we have to remove a child because of dangerous circumstances that put that child at risk, our first responsibility is to work with that parent to fix whatever the issues are with that parent, so that parent can become a parent that can care for that child. One of the questions that we ask at every hearing, that I ask at every hearing, is to the social worker, if you would find that child with these parents in their present situation, would you remove them? If the answer to that question is no, then that kid should go home. Because our responsibility is to help those parents, and we hope they will shoot off like a rocket and be the best parents that ever were around, but we realize that that's really not going to happen in most instances. But our responsibility is to help them create a family unit where that child can be cared for and will be cared for adequately. The fact they might have been in a foster home where they were in a much better house, much better school district, and all of that, we can't consider that, because it's not a question of foster versus family. It's a question of whether or not CPS has met its responsibility to raise the competency of that family so they could take care of that child. And if they've tried and they failed, then it's time for the plan to change from reunification to some other permanent plan for the child. And I agree that these kids that sit in foster care for months and months and months, somebody's not doing their job. And that's the bottom line. It's the court's responsibility and it's CPS's responsibility to get that child to permanency as quickly as possible. You're right, the preferred permanency is reunification. That's what the Constitution says. That's what we want to meet. And we also know that when these kids turn 12, 13, 14, 15, that's going to be an issue. Why was I taken away from my family? Where is my family? And they go through all of that during that period of time. But beyond that, our responsibility is to put that family in a place where they can care for the children, and under our laws, we wouldn't remove the children from them.
Well, but
I'm
to Nancy,
going to recognize the Chair Wiggins, and then after that, because we've had a healthy conversation about this, and I definitely appreciate your comments, and I'm so glad that we had foster parents who are a part of this task force, so I'm going to recognize you for the last words.
yeah, and it was to Lindsay. So is the training of foster parents such that, like we were saying, it's a liberty interest, which makes so sense. Are they trained to know that and understand that, how significant that is? And I go back, I still see it where the scenarios I've given, they're still saying they're better with us, and you even said it, and you may be talking with family and not direct parents, but is the training appropriate for this understanding?
Yeah, I think as a foster parent that reunification is the goal. So I do agree with that. I think what is not clear, and I know I'm using the term kind of interchangeably, that you're not really told that putting them with any family is a goal over them being with you. And so it seems like you could be working toward reunification with the parent, and that's fine, but then when they say, oh, we found Uncle Joe, he's better than you, that's not really fair, because you're not really given that explanation. Allison, do you think that's fair? I mean, so yeah, as a foster parent, you know that reunification is the goal. And I agree, it's not about like who has more money and all that kind of stuff. But my issue is more with these extended family members, not so much the parent. If the parent comes back on the scene and they're clean and they want that kid, like foster parents get that. But what you don't want to see is a thriving child taken to an unknown cousin just because they're family.
Last question. So in where you say some judges favor any family placement over foster care, what reasons do they give in those cases, if any?
I don't really have any except that they're family. That's what I've
They're
heard.
family.
Yeah.
There is evidence to suggest that family connections, kids move around fewer times, and that they have better outcomes when they're with family. I'll go ahead and tell you, we can do a better job of training foster parents, and we're working on that. I think that's something that should be made clear from the outset. Extended family, yes, an unknown great aunt from Alaska, maybe not. It's always you got to weigh factors. I would just add to what Judge Hudson said, if you would indulge me just a second, that the goal is reunification of the family and to protect that constitutional right to family, except that there are aggravated circumstances. And when a child's been bludgeoned and is in ICU, we should bypass reasonable efforts, and our laws allow for that. And I would say that our system does not necessarily consistently do that. I think there's been a tendency to rely on CPS to make that determination. That's a legal conclusion that aggravated circumstances exist. It needs to be raised by whomever prosecutes the case. And we certainly need to do a better job of making sure all the evidence is there in those circumstances, but that's about 10% or fewer of our cases.
Well, Ms. Simmons, again, thank you. Like I said a few minutes ago, we're so grateful for all the input, especially the input that we're getting from our foster parents. And Judge Pierce, Subcommittee 3, were there any other?
That was all. That concluded our report.
Well, thank you, and thank you, Judge Pierce, thank you, Professor Calder, and Ms. Simmons also for your input. The next item that we have on the agenda is the determination of future meetings and the drafting of the report to the legislature. So we have two outstanding attorneys that have been with us throughout all of our meetings. That's Ms. Gwinnetta Tatum and then Mr. Ethan Samsel, who's been in the back there from the Senate. And so I would propose to having Gwinnetta and Ethan involved in the drafting of the report, and then they also have the peer committee as an extra resource. I think that they would be able to, both Gwinnetta and Ethan, to handle that with no problem whatsoever. And so we need to look at a date for our next committee meeting. We have Thanksgiving that's coming up. I will say this, even though Gwinnetta and Ethan won't say this, in the midst of drafting this report, they're also in the midst of drafting all in my bills and Chairman Wiggins' bills, and the members of the House and the members of the Senate's bills. And so I want to make sure that even though they can handle it, we have the utmost confidence in them. There's also Thanksgiving, and I want to make sure that we're able to discuss these recommendations and we can get a final report drafted by them. So with that being said, what I wanted to propose to the committee, and Chairman Wiggins, you jump in here and voice your input in this as well. What I wanted to propose is that by November the 3rd, which is next Friday, that if Gwinnetta and Ethan could just compile all of the recommendations from Subcommittee 1, Subcommittee 2, and Subcommittee 3, in a document that we can email to the entire committee. And then Professor Calder, I know that there were some issues that you presented about that you wanted to talk to Commissioner Sanders and CPS about. So if you could have that to us by the 2nd, which is a week from today, that way any recommendations that you have after talking to Commissioner Sanders, we're able, Chairman Wiggins and I, to include that and the overall recommendations that Gwinnetta and Ethan will prepare, and we'll send out next week, next Thursday. And then if we could meet one day the week of the 6th, I know the 7th is a busy day. What about the 9th? November the 9th, which is on a Thursday, for us to come back and meet. That way you will have had time to review all the recommendations at that time. What we're going to be voting on simply is what recommendations we want to include in the report and which ones we feel like we need further study, or it may be that the task force just doesn't want to pursue. But I definitely think we do need a meeting where we decide what we're going to recommend to the legislature.
I'm unavailable that day, but
Oh, give me another day.
that's fine.
No, give me another day. What day are you good for?
Thursday?
Yeah.
Wait too late.
What day is good for you?
Chairman, would it be at this same time at 2 o'clock?
It would be at 1 o'clock. On that day, that's a conflict for you?
I do have to be in a court
Okay.
in South Mississippi. That Friday is completely open.
That was good, that's what I was going to say.
So the Friday, the 10th, is that good for everyone? Okay, the Friday, the 10th, is that good for you?
Oh, no.
That's what she was,
I don't wanna
Gwinnetta
be
was just
there.
telling me that we're closed.
That's why it's open.
Well, let me ask you this. If we met, and this is to council, if we met on the 13th, if that day is good for everyone, will that give you and Ethan time to prepare? Because the next week is Thanksgiving and the next week, so would that give y'all enough time? Yes? What about the 13th, that Monday? Is that good for everyone at 1 o'clock?
Y'all do it without me.
I have a hearing that day.
Okay. So,
What kind of hearing that day, Denise?
14th. I have a conflict on the 14th and the 15th. So, what time is your hearing, Professor Calder?
Well, it starts at 9:30, and I'm just never sure how long it will last. It might be over by noon, but I'm never sure about a Chancery Court matter.
But if the 9th was working for most everyone.
No, it wasn't. No, but the 10th was,
Which is the holiday.
which is the holiday, right? And so,
About 2 o'clock.
no,
Just go with Monday.
no, that's okay. What about the, let's see,
20th. I think we're getting later, but
what about the 8th? Is that good? Is that good for you? What about the 20th? Now, we're really pushing it because that's the week of Thanksgiving.
which is why things are open up. But anyway,
So is the 20th good? Could we do that morning? The 20th at 10? Is that good for everybody? All right. So we're going to set our next meeting for November the 20th at 10 o'clock. And what I would recommend I believe Cassie has all subcommittee reports from 1, 2, and 3, but I think that they may be PDF. I think it would help Ethan and Gwinnetta a lot if you could email Cassie your reports in a Word document. So email those reports to Cassie, and we'll have those for council. And then we'll just come in on the 20th, ready to rock and roll. All right, so we're near the end of our meeting. I want to just take a point of personal privilege to say I want to thank every member of this task force. You've worked so hard, so diligently, attended all the meetings, and to subcommittees 1, 2, and 3, outstanding work. And I also want to thank CPS for preparing the minutes, and thank Pat, Cassie must have stepped out, but I want to thank Pat and Cassie especially for them helping Chairman Wiggins and I facilitate these meetings, doing everything from making copies to disseminating the agendas and all the material and coordinating the Zoom calls. Thank y'all both so much. Thank you, Gwinnetta and Ethan, as well, for your hard work and your counsel. And I'm glad to see Commissioner Sanders. Your team has been here. I know you have a busy schedule. Thank you for attending. Thank you also, Judge Hudson, for coming as well. My desk mate, she sits on my row, Representative Robin Robinson, was here, and I was so happy to see her. I wanted to recognize her while she was here, but I dare not adjourn the meeting without just saying how happy I was to see her today. And I just want to ask you to keep her in your prayers, because her husband, Public Service Commissioner Sam Britton, passed. The funeral was, I believe, on Monday, and she made it up here today for the task force. And so please remember her. I hate to lose her. She got elected to the Senate, so she'll be over there with you. But just as a special request, please keep her in your prayers. And I'm going to turn it over to Chairman Wiggins before we adjourn, because I'm sure he has some comments as well.
Well, I'll just echo what Angela said. This is the hard stuff that goes on outside the legislative session, and people can see it, but this is what truly matters when you get to the meat of the coconut. And I wanted to say, I think you did it, Angela, but at the invitation of Judge Dickinson, I sat in on a family court the other week, which I think he invited a lot of people, and it was truly great. Did you do that, Angela?
I made the invitation, but I wasn't able to make it.
Okay, it was, and I appreciate what Judge Dickinson is doing. And in that case, I don't think he minds that. It was a father, I think it was 4 kids, but had drug issues, mom's out of the picture, and he did everything that was asked of him. And, everybody was thrilled, which you don't normally see in youth court and all that. So I took him up on his offer, and it was special. And I was there as senator as opposed to like a lawyer. So, so those are the bright lights that don't get talked about. And I think because of the confidentiality, you don't see it. But it was special. So if you get to see it, we are making a difference. And I think it's only going to get better. And man, if everybody could be like Harrison County in that sense, and I think that's the goal, is trying to, I will say that in some of your, as Judge Hudson said, your urban counties, they've been through a lot and they see it, and trying to take what they've done and replicate it somehow in these more rural counties, I think would go a long way. So I appreciate Judge Hudson Judge Dixon for making the invitation. So making progress. So thank you very much.
Yes, thank you. Judge Dickinson, everybody who's sitting around the table, everyone who's participating remotely, your contributions have been just absolutely outstanding. And Chairman Wiggins and I can't thank you enough for all your time and your input. And with that being said, if there is no further business to come before the task force, we'll entertain a motion to rise and report.
Rise and report.
All right, all those in favor, aye.
Aye.
Thank y'all, see you on the 20th.